So for those who do not know me, again, my name is Anthony Bandiero. I'm an attorney and senior legal instructor for Blue to Gold Law Enforcement Training. I like to say this is what I do for a living. I have the honor and the privilege to train cops all around the nation in making good case law. Nobody alive today that I'm aware of, okay? I think Zach may be a close second, but I think I've taught more cops search and seizure than anybody in the United States, and only because I've been teaching a tad longer than Zach Miller, my other co-instructor, who is here today. What's up, Zach? So, guys, I'm glad you're here. We also have a search and seizure book for every state from Hawaii, California, North Dakota. We actually sold a book to every North Dakota cop last month. Rick, it was like what, 25 books, right? So we got the whole state. Now, if you want a search and seizure book, go to the store. Rick will put the link in there and so forth. But check out the search and seizure books. They're amazing. They're really up your alley. They are written for you. They're not written for attorneys. There are a lot of attorneys here, and I love them here, and I appreciate them being here, but they're not written for that audience. It's for the hardworking, busy police officer that needs to know what the law is in every situation they encounter, right? They're all 50 states. And so last time I checked, Nebraska is still a state, barely, right? Barely, okay? So also, Teresa here is here. She's our social media director. She really does a great job of social media. She's pumping out videos every single day. Teresa, how many videos approximately do we have on YouTube? Over 1,000. I know that's over 1,000. We have so many videos on Instagram and so forth. 1,000 plus videos on YouTube. Guys, check it out. It is absolutely for your your education. A lot of cops are watching these, while on duty, in the the break room, or at the roll call and so forth. All right, let's do some quick disclaimers. Number one, laws and agency SOPs may be more restrictive. This is a national audience. That means that I'm teaching to the Fourth Amendment standards, right? Some states are going to have more restrictive standards. Some states are not going to allow you to do some of the stuff I'm talking about here today. Also, even if they do allow it under state law, under state case law, some agencies are more restrictive. You know what? That's not a bad thing. Okay. I mean, when I read the Supreme Court cases around involving hot pursuit of a motor vehicle and how the person is dangerous and so forth, you know what the impression I get from the U.S. Supreme Court? Chase it till the wheels come off. That's my legal interpretation. My legal interpretation is the Supreme Court has made it very clear in all these cases that you chase these people until the wheels come off. Now, last time I checked, the policy does not say chase them till the wheels come off. It says no misdemeanors. There has to be a violent felony. If you cross into other jurisdictions, there's more considerations. I've seen policies that say that the original crime is not considered. I'm sorry, the original crime is it will be considered, actually. So if you originally try to pull them over for a taillight violation, then they start driving reckless. Well, we still look at it as the original violation. These are all restrictions that the agency is putting on themselves, and you can't blame them because they also have to worry about the taxpayer and liability. If you have any doubts about the legality of your actions out there, push it up the chain. Okay, this is your time to get your questions answered from me. But remember, though, I'm not an end-all be-all. Remember, you have to chain of command. And finally, I'm an attorney, but I'm not your attorney. So get your questions answered. Now, at the end of this webinar, I'm going to answer your questions. I'm going to see if my friend Zach Miller is available and he can stick around and answer your questions too. And it'll be both of us. But any question, okay? I don't care if you're from California, New York, Texas, or North Dakota, right? So if you have a question about, any search and seizure scenario, you know what? Let us know, okay? And Zach and I will try to answer the question. All right, so we got a lot to talk about, and we're gonna move fast here, okay? This is how the Blue to Gold webinars work. I want to keep you interested. Also, I value your time. I value my time. So we're gonna get up and rocking. Okay, so unprovoked flight. We're gonna talk about hot pursuit, fresh pursuit, protective sweeps, plain view seizures. Let's get into it. So unprovoked flight, let's start with that, right? So unprovoked flight is a common thing that happens in especially high crime areas. Now, one thing we know, the Supreme Court said that any refusal to cooperate without more does not furnish the justification needed for a detention or a seizure. Makes sense? But unprovoked flight is simply not a mere refusal to cooperate. Flight, by its very nature, is not going about one's business. In fact, it's quite the opposite. So we have this first thing of, hey, unprovoked flight, they're fleeing from you, they see you, they start running, and so forth, right? That's awesome. So the three things that I kind of look for with unprovoked flight is number one is criminal activity, right? So you got to associate this flight with criminal activity. It's not hard, high crime area, high crime house. It doesn't mean it's your stereotypical, high crime area. It could also be a very nice area, right? Like the Palisades in California, right? Beautiful homes and so forth. And they see the officer, and it could be, the Palisades, but it has a high crime house, right? They see the officer and they start this unprovoked flight. So it's headlong flight without provocation. So you want to describe that area, right? You want to describe like maybe what is going on here. Again, you don't have to be very specific, but you can say something like, hey, they were, hanging out at a known drug house, saw me and just started running for the hills. You want to articulate why they knew it was a police officer, because the one argument that I can see coming up in some of these cases is like, hey, you were driving around in an unmarked car, that Camry. How did I know it was a cop? You just said yourself it's a high crime area and people get shot out here. I thought you were creeping around the neighborhood, and I thought you were the bad guy. I also described the headlong flight. So let's watch a video and see what I mean. Now, all these videos are fair use, so let's evaluate the video and take it for what it is.
Yo, give me a break, man. Hey, yo, slow up.
Now, I show that because in Snoop Dogg's way, was he fleeing, right? Was that headlong flight for Snoop? Yes, it was. He was going as fast as he can in his wheelchair. The point is, it's not like you got to be running, at full speed if it's not possible, right? So let's talk about Illinois versus Wardlow. Now it says, and this is also a Miles case. Now, one of the best movies, right, Devin? One thing I want to kind of caution you on is that some courts seem to be receptive to an argument that, you can provoke somebody to flee. Okay. I don't think a lot of courts are really, by that. In other words, this was a case in Miles where the officer was targeting this guy with a flashlight, using a flashlight. I don't know. I'm not sure if all courts buy that, but the court did say a suspect's flight at the sight of officers who are targeting him with a flashlight may provide a basis for fear of harm that has nothing to do with whether the suspect is engaged in criminal activity. Okay, so look, it is what it is, right? Some courts are, using other factors to determine whether or not a person is really engaged in unprovoked flight. In other words, they're saying that sometimes the officer is actually engaged, like provoking the person. Now, again, whether you believe that or I believe that, I have my doubts about whether that's the legal rule here, but it is something that you want to be prepared to talk about. So let's watch another video. All right. So I show that snippet because, all right, let's try to argue, unprovoked flight. Now, some courts may be receptive to this argument that, if he is saying, come over here, and then the guy runs, and if that's an unlawful order, then that may not be unprovoked. But I think most courts are not going to buy that, quite frankly. Most courts are going to say, hey, look, at the end of the day, is he fleeing headlong flight at the side of the officer? The answer is yes. Did he ditch the gun and the drugs before he was captured? The answer is yes. State versus Roe. So what happened here is basically the elements are high crime area, around midnight, standing next to an idling car. The door was open, ran immediately after the officer tried to talk to him. That's a classic, unprovoked flight. Another case was where a high crime area, I don't have the citation on this one, but a high crime area, late at night, anonymous tip of drug sales. And then the officer tries to approach the house. This guy's sitting on the stoop, and he turns around and says 6-7, whatever that means. They have like code, right? They got code now, 10 codes, and then he starts running away. The court there found that this was unprovoked flight. Okay, so I want to skip that case. All right, hot pursuit. So actually, no, I'm gonna show the beginning of this video. I'm gonna show the video, but we're not gonna watch the whole video because we don't have time. Hold on. All right, so I don't show the whole video. We don't have a lot of time for that, but the point was that was classic, right? Unprovoked flight, high crime area, known officer. You know, we're not going to have this argument that I didn't know you was a cop, right? And also, he ran after seeing the police officer. That is a classic unprovoked flight case. Now let's turn to hot pursuit. The one thing I want you to know, though, is that I try to choose my words wisely, okay? But also, this is something where some courts call fresh pursuit hot pursuit and hot pursuit fresh pursuit. Look, that's fine, right? I mean, it's not like, Black's Law Dictionary. This is, black and white and Black's Law, no pun intended, and that all courts have to use the same language. But let me just tell you the way I teach it here, just so that the brain is understand what I'm trying to teach here. To me, hot pursuit is when you are hot on a suspect's tail, right? I want you to think about it. You're hot on a suspect's tail, meaning you're trying to catch him. Fresh pursuit, the way I think of it, is you're hot on a suspect's trail, meaning you're trying to track that person down after committing a very violent crime. But, some statutes will say fresh pursuit, right? Fresh pursuit when they really mean chasing people over state lines. That's fine. I just want you to recognize that's how I use these words. Now, when I talk about hot pursuit, you may chase a fleeing suspect into their home. This is this is why it matters, right? You're not going to have an issue chasing a fleeing suspect into Burger King. You're not going to have a problem chasing them into their car and grabbing them out. You're not going to have an issue them going into a third party's home. Not with them. They can't challenge that. The point is, though, if you're going to chase them into their home, what you reasonably believe is their home, then it has to be any felony. Right now, that's what the courts have said. Felonies work, even though I'm not sure I totally agree with that. Or a misdemeanor if exigency exists. I believe is warrant pursuit. How dare you, Zach? So I don't think that we can chase people into their home for any felony. Okay, I think that's ridiculous. There are so many felonies, right? Exactly. There are so many felonies out there that are, when the founding fathers, when they said a felony, that means that you're getting capital punishment, right? Here, bouncing a check is a felony. Cutting off the tag of a mattress when you're not the final purchaser could be a felony. I'm maybe making that up, but the point is, there's a lot of felonies out there that really are not really what the courts are talking about, right? They're really talking about some kind of exigency, right? Some kind of exigency. Absolutely, face that wall. Now, our seminal case is Santana. This is Santana's home, the one on the right. I don't know if, actually, I can annotate it. Oh, look at that, huh, Rick? Check that out. So that is Santana's home right there, okay? And it's a beautiful house. Nice 2-story, maybe a 3-story. And what happened here is that Santana was a drug seller, okay, dealer. And when the cops went to her row house to arrest her, I think her name was like Ma Santana, like her nickname was Ma. And they're like, "Hey, Ma, you're under arrest." Now, at the time they said you're under arrest, she was leaning in a door frame. I think that's she was like, yeah, Mom Santana, right? I thought one of the cases said Ma, like not Mom. But anyway, regardless, she was leaning in her door frame. And she was allegedly selling drugs. So they had the PC for her. They got out of their car. They said, "Hey, you're under arrest." She flees into her house. They chase her. And the question for the court is, was that legitimate hot pursuit, right? So the cops are right here and they chase her, into the house. Was that legitimate hot pursuit? And because remember, hot pursuit is only legit if it starts from a public place, a place where the officers, are allowed to be essentially, right? And the person is in a place where the cops can access them. Well, the court is basically faced with this determination of, hey, we got to call that, we got to call it here. We got to give cops, a bright line rule here. And the court said that this was basically a public place for constitutional purposes, right? So, as the court said, by retreating into a private place, her house, defendant could not thwart an otherwise proper arrest that has been set in motion in a public place. The threshold of her house, and that since there was a need for the police to act quickly to prevent the destruction of evidence, narcotics evidence, there was a true hot pursuit. And therefore, the warrantless entry by the police into the house to make the arrest was justified. Now, I still believe that even though this was a felony, drug sales, and so forth, I still believe that the court wants agency in these cases. And there was certainly agency with Mom Santana, right? But also recognize that if somebody's in their house, okay, and you didn't chase them in there, okay, but you know that they're in there, you're not going to be able to call this hot pursuit, okay, because it did not start from a public place. Also, you're going to have to realize that the severity of the crime does not allow the entry. Peyton, which is a top 3 search and seizure case for us instructors, he committed a murder at like a gas station. He murdered this cashier basically 3 days prior. The cops think that he's home. Now it's not really chasing him. Obviously they're not chasing him on his tail, but they're still trying to get him in custody, right? And the court made it very clear that the Fourth Amendment prohibits the police from making a warrantless and non-consensual entry into a suspect's home in order to make a routine felony arrest. Let's talk about Lang versus California. Here's what happened. Arthur Lang was driving down the street. He was very close to his house, within 100 feet or so, and he's bumping some music. And I think he was also like honking his horn, basically calling attention to himself. And he pulls into his garage. The cop tried to pull him over for a loud music. He pulls into his garage. I guess he tries to shut the door on the cop. The cop breaks the beam. The garage door comes back up, and the cop enters there. He ends up arresting Arthur for the actual noise violation and also the drunk driving. Now, it wasn't articulated that he was a drunk driver at the time, but the lower courts are like, hey, look, this is good to go. It's hot pursuit. He didn't stop. It doesn't matter what the crime is. Misdemeanor works for us. And the U.S. Supreme Court did not agree. Okay, they said basically you got to have something more than just a misdemeanor. You got to have some form of like exigency, right? You got to have safety issues. You got to have destruction of evidence. You got to have imminent escape. Render aid, safety issue to you. Any felony, but I should put an asterisk on that. But the point is that this is what the court basically held. Right now, I still believe that if you are trying to make good case law, you should not be chasing people into their homes again just for any felony. I think that's problematic. I really do. All right, let's watch this. Now, let's just talk about it. Look, we don't know the whole story. Well, I kind of do actually, because one of these officers that was on scene was actually in one of my classes. So I just try to pick his brain about if I was missing anything. But at the end of the day, let's just presume that they have misdemeanor obstruction. Okay, misdemeanor obstruction. And he's chasing that guy into the house. Is that enough? Right? I mean, is that going to be enough to break that door down? I wouldn't do it. I wouldn't do it. I don't think that's in the spirit of what Lang versus California said. I think they want something more than that. So I guess it's a good thing that the door didn't break open, right? Because if he would have went in there, and they would have went in there and used the force and so forth, maybe that could have been, an issue. So Anyway, I think that we got to be careful with that. Bailey versus Swindell. This is actually a very good case to remind us that okay, even if you have a mandatory arrest, a shell arrest, that does not give you the authority to chase people into does not allow you to enter homes to make an arrest. Now, this is a hot pursuit case. Okay, so what happened here was, I think Bailey, but I may be wrong. But Bailey violates a temporary protective order. That is a mandatory arrest in the state. It's disobeying a court order. He went to his ex's house, harassed her. He wasn't supposed to be there. We're good to go with the arrest. But the guy, steps out of his house a little bit. And then he runs into the house. The cop chases him. There was a debate about whether or not he was already inside the house, but the point is that the cop is like thinking, hey, this is a mandatory arrest. Well, the mandatory arrest does not get you into homes. I mean, just like Peyton. I mean, Peyton was a murder. I mean, it wasn't necessarily a mandatory arrest statute like there's TPOs and DVs, but you still need to get into the house lawfully. You need to think about how are you getting in there, right? How are you getting in there? So we have expressly refused to read Santana as allowing physical entry past Peyton's firm line without a warrant or an exigency. Santana's description of the doorway of a house as a public place, we have said, shouldn't be misinterpreted to mean the officers have a right to enter and arrest anyone standing in an open doorway without a warrant. Okay. So one thing too is, look, if you do have a legitimate hot pursuit, do you have to go head first into that house? Do you have to chase him immediately? Or can you wait till the cavalry? Well, the Fourth Amendment only prohibits one type of search or seizure, the unreasonable one. Would it be reasonable in some situations to actually wait for your backup? Absolutely. So if you have a legitimate hot pursuit, the courts allow you to wait a reasonable amount of time for your backup to come. You do not have to get a warrant. The courts will consider that be continuous. Okay, that's very, very important. Okay. Okay. The other thing that comes up here is, all right, Anthony, I'm chasing somebody. It's legit, but I lose sight of the guy, and then I kind of track him down to this particular apartment, and now I try to make a forced entry. Well, the question is, was it hot pursuit? Were you actively trying to pursue him? And soon after, did you find where he was located? If the answer is yes, this is going to fall under hot pursuit as long as the other things are in play. Lang versus California and so forth. Okay. Now look, losing sight of somebody, it happens. It's like chasing a guy in a car. And then you see him, a few minutes later driving on a different street and he's obeying the speed limit. But yet you just got done chasing him for 15 minutes. That's going to be okay, right? I would say, look, at some point, this hot pursuit may become stale. It may not be actually hot on the suspect's tail anymore. And so at that point, you may want to get another reason if you have some kind of exigency, consent, and so forth. All right, now let's talk about fresh pursuits or warm pursuits. Warm pursuits. I'll be in warm pursuit of the suspect. So, lukewarm. So, you may enter a home after tracking down a suspect. This is why it's warm, right? Because the crime just happened. You have reason to believe they're inside. They're extremely dangerous and so forth. But I want you to know that fresh pursuits are for really violent crimes. Fresh pursuit is not for bouncing a check, even if it's felony level, right? Fresh pursuit is, generally speaking, not for strong arm robbery. It's for armed robbery. Fresh pursuit is for murderers and shooters, and drive-by shooters and so forth. They're for really violent people. So here are some factors to consider. And, Rick, maybe you can kind of just put the Search and Seizure book as a reminder, because these factors are in there, like the gravity of the offense, right? What are we dealing with here? Okay, just because it's a felony does not mean it's all fresh pursuit. We're looking for very violent people, right? Belief the suspect is armed. That's um, a very common factor that the courts will articulate when it comes to getting a person in custody as soon as possible, because armed people are dangerous people, right? Well, when it comes to them committing crimes. Clear probable cause. The more probable cause you have, the better. We don't want to kick people's door in for very flimsy cases. I guess that's my point. Suspect may escape. Violence used to make entry. Look, the Fourth Amendment is always about balancing privacy and the government interest, right? There is a stronger government interest in breaking down the door to get a murder suspect in custody than a person who is smoking pot in public, right? We're not going to break people's door down for smoking pot in public, okay? And Rick, I'm sorry. So, State versus Campbell. So, this is a good case. What happened here was, after an armed robbery, police tracked the suspects in the snow. Again, armed robbery, damn serious. That's a very serious crime, obviously. 45 minutes later, police saw the suspects inside the house and entered to make the arrest. Are we good, right? And the answer is yes. They thought that this was like a quintessential fresh pursuit case, warrant pursuit. You're fresh on this suspect's tail. Let's talk about People versus Gilbert, a very sad case where a police officer got killed. A bank robber killed a police officer and escaped. Police tracked the suspect to his apartment 2 hours later and arrested him. Does this fall under fresh pursuit? The answer is yes, right? This is a violent person that needs to be taken in custody. We don't have time to get a warrant. People get hurt. Evidence gets destroyed, and so forth. He may escape. Let's get this guy in custody. Let's watch a video. Let's watch. This is my Snow Whisperer case, okay? You're going to be very impressed with this police officer. I guarantee it. Actually, a little bit different case.
No, it's not cool. Him too. Put it out. Get it out. Oh! What? Okay. Okay. Money in the bag. I touch nothing. I touch nothing.
Under.
What? Where?
Under the thing.
Where? Here? Where? The Newport? Okay.
Yeah.
All right. So look, is that a good fresh pursuit case? Let's say that you saw that wallet that he left behind, right? And you opened it up and you saw that the guy lives at 123 Main Street. You get to Main Street and you have reason to believe that both suspects are in that house. Do you think you have the authority, if it's done safely? This is not a safety class. It's not a tactics class. This is a legal class. Do you think that you can articulate fresh pursuit in that case? If it happened within, you tracked him down within 30, 40 minutes, right? Andrew says yes. The answer is yes. That is a fresh pursuit case, okay? I'm not telling you to be unsafe. I don't want you to get hurt out there. Get the cavalry there, right? I am a smoke the person out type of case, okay, type of person, okay? So what if we do a surrounding call out and they won't come out after look, if the law is this, okay? If you start a surrounding call out, if the surrounding call out was started with exigency, then it continues until it's done. Okay, Daniel? Or no, Brayton, right? It continues till it's done. There is no, like the courts do not require that if you started the intrusion, which is the surrounding call out, with exigency, and you still had time to go get a warrant, they do not require that you break somebody off of the scene and go get a warrant. You don't have to do that. Does that make sense? So you just keep on going. Now you're good, Daniel. Okay. Let's watch another video. All right. Man, that guy is legit. That is legit, man. I mean, he's fucking a tracker. I mean, it's awesome. But that is like when I saw that, that is just a good example of fresh pursuit, right? Don't you guys agree? The cop is, is fresh on the suspect's trail. Now, this case, just so you know, is probably not strictly speaking a fresh pursuit case. And why is because he's not at his house. Is that right? Is that, it's really as fresh pursuit cases is when they have a privacy argument. He can't even argue. He can't argue, even if the crime was not that severe, right? He still can't argue his arrest because he's not at his own domicile. He actually is committing trespass, to say the least. So but if this, imagine that this was his house, that'd be better. Let's talk about protective sweeps. Now you chase somebody into their home, okay? Now you got to think about what can I do to be safe? There are 3 protective sweeps or zones, as some people call it, when you're in the house and you've actually made the arrest. Number 1 is areas under their immediate control. That is Chimmel. That is where they can grab a weapon, they can destroy evidence, they can, means of escape and so forth. It's while the person is being arrested, after the person has been, is in control, they cannot, reasonably access any areas around them anymore. That search stops. We also don't get to like move the person around the house and say, now that you're near this dresser drawer, let me search that too. It doesn't work that way. Number 2, it also includes adjacent areas. Okay, now this one is automatic, okay? So immediate area where you think that they can access items, reasonably access items, not just, too theoretical. It should be something that they can access. Adjacent areas. Okay, so this is like when you're in a home and you arrest them in one room and there's another room connected to that room, right? You arrest them in their bedroom and there is a bathroom that's connected. You can go into that bathroom area and look for people in people-sized places, right? But you're not going to be able to look in the medicine cabinet. You're not going to be able to look in the toilet bowl tank. If you want to play the whole, I want to look under the sink, the cabinets. Hey, look, if a person can fit there and it's reasonable, you should be fine, right? But be reasonable. I mean, some cops are like, yeah, we're taught the basketball rule, If a basketball could fit in it, we can search it. A basketball seems a little small to me unless you're looking for garden gnomes. Tyson says if someone runs into a house that is not theirs and police lawfully enter, could the homeowner argue Fourth Amendment violation? No. That's a great question, right? So here's the deal. Okay, first of all, back up. Hold on. First of all, was the pursuit into the house lawful? Right, Tyson? Was the pursuit into the house lawful? Okay. So I think and also Tyson, we're talking about like a friend's house. We're not talking about a home invasion, right, Tyson? Obviously, if we believe that the person is in a completely random person's house, first of all, I don't see how that person would ever complain about you. They'd be hugging you, not chastising you. But I think what you're talking about is the friend's house, right? The fellow doper house. And the answer is okay. If the hot pursuit was legit, then the answer is no, because if the exception allows the invasion of privacy, right? So if it's hot pursuit, fresh pursuit, and it's legit, that gives us the right to invade on people's privacy, right? But if the invasion was unlawful, meaning let's say we're chasing somebody for a misdemeanor that has no exigency, and he goes into his friend's house. Well, I got good news and bad news. The good news is the suspect, the one who ran into his friend's house, he cannot sue. Okay, he can, but it's a loser of a case because he has no standing. But the friend can sue, and when the friend can put the cop on the ropes and say, "Hey, what gave you the authority to go into my house?" Because I have standing. I'm allowed to keep you out unless you have a reason to be in my house. And so the answer would be that would be a viable lawsuit. Okay. Finally, that's a great question. Finally, throughout the home, right? So this is where the cop is in the living room, for example. They got the guy in custody. But, another officer wants to sweep the house and make sure everybody's safe. Well, it can be done if it is articulated, right? It requires articulation. It requires some facts or circumstances that that the house can harbor somebody that is posing a danger. Now, let me just tell you something, okay? The first one, immediate area, adjacent areas are automatic, okay? They come with the arrest. This one requires some articulation, but it's not hard. I think courts inherently reasonably understand that when you're in a house arresting a person, you're in a very precarious situation. They get it. They feel for you. However, give them something objective. A lot of cars in a driveway, gang house, this crime is associated with other people, things like that. If you just give them nothing, then it's hard to back you up, right? You got to give them something. You got to give them something. All right. So look, lawful hot pursuit. First of all, yes, because he has a warrant, right? The warrant is the authority, right? That is easy, right? Um, if it was not with the warrant and there was something else, if it was like a PC charge, then we had to analyze laying, right? Is it a misdemeanor? Is there some kind of exigency? Even if it's a felony, I think Santana, if you read it, it does talk about exigency in there. Is there some kind of pressing need? Okay. The next thing is, what protective sweeps may be conducted. Well, don't forget, you have two automatic searches that come with the arrest. Search incident to arrest, and you have adjacent areas. Could you go into that little room and look around for people in people-sized places? The answer is absolutely. Could you go into the living room and look? Yes, it's an adjacent room to that location of the arrest. Could you go throughout the house? Only if you can articulate that there is some kind of danger, like and it's not hard. Now, what about the reentry? The reentry, I think, is problematic here, okay? There is no let me show my sergeant some cool shit exception, okay? That is not that's not really why we go back in the home. So, right, the house is the most protected structure under the Fourth Amendment. It's not just a structure; it's the most protected thing. It's more protected than your body. There's all kinds of things that we do to people's bodies: search incident to arrest, visual cavity searches. I'm just saying, like, there's all kinds of things that we do as a matter of routine when people are booked into jail, into general population that we do that very intrusive things. But step one foot in somebody's house without lawful authority, and you can get jammed up. Here, the reentry was problematic. However, if you have a reason to reenter, and it also is continuous, meaning you're not taking commercial breaks. What if that that screwdriver was evidence? Could you reenter and go secure him, go grab some gloves, go get your work camera, get a paper bag to put it in? Could you go back into that house and go secure that weapon that if he used it against the cops? Absolutely. Absolutely. That would not be suppressed. But if you called CSI, right? If you called CSI and they took 35 minutes to get out there, that's a problem for me. I don't know. I don't know how unless you're inside the house, unless you are not leaving the house. I guess that's one way around it. But if you're going to sit in your black and white and you're going to be, with the air conditioner on, listening to jazz music while CSI is on the way, or you're watching Blue to Gold YouTube videos, then look, I'm glad that you're learning, but maybe you should watch a video on re-entering homes. Okay, plain view evidence. So good. Here's what we got unprovoked flight. Check. We have hot pursuit. Check. We have fresh pursuit. Check. We have protective sweeps. Check. Now let's talk about plain view seizure. And Bo actually says Bayou. Bo says we typically keep someone in there, but at that point they will get a warrant anyway. Okay, yeah, Look, that's the cleanest way to do it, right? So, plain view is plain view. There's plain view and there's plain view seizure. Plain view is right to be, right to see, right? There you go, Jordan. Right to be, right to see. If you're lawfully present, then you can use your God-given senses, right? So you're lawfully present. It's immediately apparent, with no manipulation. Now, when it says immediately apparent, I want you to know that it doesn't have to be like, oh my God, that is a stolen laptop right in front of me. Let's say, for example, you're inside of a house for a domestic, and you're there for you're there as a cover officer, and you're looking on the table, and you see this laptop with a blue to gold sticker on it. And by the way, we got those amazing stickers at the store. You see a blue to gold sticker on the top of this laptop, and you're like, oh my God, I think that somebody at Starbucks had their laptop stolen when they went to the restroom, and it had that sticker on there. And you call up your detective, like, hey, Billy, I'm at this domestic. Uh, did that laptop that you took a report for last night that got stolen at the Starbucks, did it have a sticker on it? Oh, yeah, it had a beautiful blue to gold sticker on it, right? Okay, cool, right? What it look like and so forth. And so was it immediately apparent? No. But did you manipulate it? No. Now you're good to go, right? Right to be, right to see. Now the next thing is, do you have lawful access? Can you just go over there and grab it? Absolutely. The key here is that you have to have lawful access. I think a great case on this example is Lewis. In a nutshell, what happened here is that the cop is patrolling a neighborhood. He sees Lewis. He thinks he's packaging narcotics. Lewis sees the officer, and he puts everything he was messing with in the under the stairs. Okay. So Lewis comes to the curb. He's detained. So far, so good. A backup officer goes over to Lewis's neighbor's house, looks at the stairs, and sees all the drugs in plain view. Is that right? Plain view. Okay. Then he goes over to Lewis's curtilage and seizes the drugs that were in plain view. Now remember, Lewis is at the curb, right? He's detained by the primary officer, and there is no thanks, you're welcome, Andrew. There is no agency here. Okay, there's no agency here. Now you see the problem here. You have to have lawful access to see something under plain view. Do you see the problem here? They went on to the curtilage without any agency, without any consent, without any warrant. That sounds like an acronym. What is that acronym I just described? Consent, agency, warrant. What is that acronym? Thank you. It is true that not only must the officer be lawfully located in a place in which the object can be plainly seen, but he or she must also have a lawful right of access to the object itself. Police officers are prohibited from entering a person's home or its curtilage without a warrant, absent consent, or a showing of exigent circumstances. This is true even when the items of contraband are visible within the officer's plain view. You can see it, but you just can't touch it. And nobody knows that more than me, okay? Do you know what a burlesque house is? A burlesque house is a gentleman's club. And what this judge said in 1975, he said, seeing something in open view does not, of course, dispose of the problem of crossing constitutionally protected thresholds. Those who thoughtlessly over-apply the plain view doctrine to every situation have not yet learned the simple lesson long since mastered by old hands at the blessed houses. You can't touch everything you can see. The point is, you can see it, but you just can't touch it. So plain view and plain view seizure are two different things. Right to be, right to see, fine. Plain view seizure gives you lawful access. And with that, my friends, please remember to share that. We're going to do some trivia, okay? But share our weekly webinars with your friends. You sign up. You don't have to be here, even though we like you here, but you get a copy of the webinar anyway. And with that, we are done. So before I do that, for my people who are watching on demand, I would really appreciate some feedback. You know what? The ticket of admission here is simply to give me feedback, to share with your friends in social media. That's all I ask. And I don't think it's that much. I could be relaxing in my beautiful hotel room at the Travel Lodge, right? Watching some good old-fashioned Smokey and the Bandit on the TV, right? Drinking a Bud Light. No, no, not a Bud Light. Miller Light. That still has an interesting connotation to it. So I appreciate you guys here. Please give me some feedback. I love you guys. I really appreciate it. Now let's do some trivia. Okay. For those who are watching on demand, I'm going to end the video for right now. You've probably seen it on, share with your friends and so forth. You are absolutely allowed to share this video with your friends, download it, put it into a VHS tape and sell it at the Blockbuster. But I do appreciate you guys. I'll see you next time and stay safe.